time for the concept of Indian marriages to endure by embracing the concept of Sarva Linga Sambhav. I mean, Your Lordships, I'll restrict my submissions in 5 minutes. My argument relates mostly to the idea of innateness, and I'll build upon the proposition which has been culled out in para 278.7 of the Navtej Johar judgment, Your Lordships. The argument about innateness, and this has briefly been alluded to by my predecessors, particularly Dr. Singhvi, is that if something is so innate to a person, then it is impermissible, and for that matter, even unconstitutional, for the state to utilize that as an opportunity and as a yardstick to impose and discriminate against the person. Sexual orientation is one such category, as has been recognized in the cited paragraph of Navtej Johar. Your Lordship, in this regard, let me just build this by an example. When a person is born, that person, while growing up, will either choose to be right-handed or will choose to be left-handed. Subsequently, through a process of choice, that person can even change whether to be right-handed or left-handed. A person can be ambidextrous. These are the spectrum when we are talking about gender and sexuality. A person can move from one to the other, can be both, can be none. So these are the parameters on which this moves. Now, sexual orientation and gender, as has been recognized in the cited paragraph, is such an innate characteristic of a person that to discriminate on the basis of that would fall the test of constitutionality. And I say this for a particular reason, Your Lordships. It is not open for the state government to discriminate, or for that matter, the union government to discriminate on these parameters. If they were to do so by using a person's sexual orientation against them, something in most cases people have no control over, then without establishing as to what is the harm which is being caused to any other person, it would fall foul on first principles with the social harm, Your Lordships. There is no harm which is being caused to anyone in this regard.
From that, what is the submission?
Your Lordship, the continuation of this is that the grant and conferral of these positive rights upon the queer community is not a zero-sum game. It is not being granted to the queer community at the expense of anybody else on the other side. The only argument which the union, or for that matter, the state government can present is that this is running contrary to the idea of social morality, of public morality, and that is the basis for them to deny this right and to deny this privilege. In this regard, Your Lordships, let me just build the argument as to why it would be completely impermissible to do it. Their argument about social morality and public morality rests in an amorphous contour which they are yet to define through their counter affidavit. Their counter affidavit, however, proceeds on a slightly hurtful, if I may say so, presumption, which is available in para 36 at page 45 of their counter affidavit, wherein they say that only one form of protection, or only the highest form of protection, is available to marriages of the opposite sex. Merely because that has been the case so far is no reason for the union government today to argue that it must also be the case going forward. They have to demonstrate as to how the conferral of these rights would dilute or snatch away the already vested rights.
Right.
And Your Lordships, in continuation of this, I would just, as a matter of abundant caution, Your Lordships have already indicated on day 2 that probably this is not an argument to belabor upon. On the concurrent list aspect, this is a part of entry 5, Your Lordships. Previous hearings have indicated that whether hearings have taken place on arbitration entry 13 or IBC entry 9, it is not a case where all state governments must mandatorily first formally be issued notice and then they come. State governments are already here. The union has already invited them. They'll assist Your Lordships. The law which Your Lordships will lay down under 141, one way or the other, whether for us or against us, will be binding upon them in terms of the meaning of Article 144. So it will not be open to them to say that merely because we were not formally impleaded as parties, we will escape the rigors of this law one way or the other. And to conclude, Your Lordships, I'll just make the submission. Your Lordships, it is part of the basic structure that secularism in India has progressed and thrived and endured because it is founded on the concept of Sarv Dharm Sambhav. Your Lordship, through the building blocks of Navtej Johar, Joseph Shine, Babita Punya, and now Supriya Chakravarti, it is time for the concept of Indian marriages to endure by embracing the concept of Sarva Linga Sambhav. I'm extremely grateful for a patient hearing, Your Lordship.
Thank you, Mr.